afternoon and welcome to the 30 Park Place Wales Education Law Conference. This is day 2 of the conference. The first day was hosted last week. We have recorded that session as well, so I'm sure that both sessions will be sent out to you for your records or to pass on to colleagues. My name's Emma, I'm the editor of Legal News Wales. We're facilitating the conference today, so I'll drift into the background, but just to let you know that we are hosting this as a webinar, so you can only see us, you won't be able to see each other, and if you do need any technical assistance, I've texted you or emailed you my number. I'll pop that into a chat function or into the Q&A, so you can all see that if needed, and just text me if you need anything. So we hope to have questions at the end if we've got time. We've got a packed schedule today, and that Q&A function is the two little speech bubbles with Q&A underneath that, and if you've got any questions throughout the course of the event, pop them in there and our team will be having a look at those throughout the duration, and if there's anything that we can answer we will, and we may be able to take some offline, so throw them in. We won't be able to see your names against them, and you can put them up anonymously as well if that helps. So enough from me. I would like to hand over to Mark Allen, who's head of the education team at 30 Park Place. Thank you.
Thank you very much, Emma. Can I then say officially welcome back to part 2. Right, am I on screen all right? I can't tell. Yes, I am getting a nod. Thank you very much. It's just because something's come up on my screen. The position today is that we again have a set of talks about the new legislation, code, etc. Can I repeat, as I said last time, that these are designed to be short reminders of the new legislation and to focus on the main points, and that's because time is limited and we don't have time for in-depth analysis, although last time I think some of the questions that we answered dealt with some of that. Can I also ask for anyone who hasn't, if you would make a donation to Snap Cymru. This is a free webinar. All of the contributors are providing their services free, but it would be very nice if you could use the new dedicated Just Giving link to give something to Snap Cymru, as I say, in recognition of the fact that you have attended this event. Today then we are having the talks to begin with Melissa Jones, who's going to look at the experts and the roles that they're playing within the new system. That's followed by a talk by Abla O'Callaghan, who is going to talk about the impact on parents and their positions. We then have Michael Imperato, who's going to talk about the effect on further education institutions, followed by Abla again, who's going to talk about the impact on health boards. And last, a talk from me about the education tribunal regulations, which will be something of a brush up, but also some of the stuff that is new. Right, without further ado from me, then I'm going to hand over firstly to Melissa to start her talk. Thank you.
Thanks very much, Mark. I'm just going to share my screen so you can see the slides that I've prepared. I'm hoping that that's all now, if I can see some nods. So I'm going to talk to you today about what the educational professionals involved in this process have to do under the new Act, regulations and the code. Now, the main provisions of the Act relate to section 60, which deals with the additional learning needs coordinator, and the corresponding chapter in the code is chapter 8, which specifies what their role involves, and they're also affected by part 3 of the regulations. And so we'll look at each of those in turn. The next main part of the Act is section 61, which relates to the designated education clinical lead officer, which is more relevant to the health boards, and the corresponding chapter of the code is chapter 9, which again specifies their role. And the final section in relation to this part of the Act is section 62, which relates to the early years additional learning needs officer, and the corresponding chapter is chapter 10, which specifies their role. So helpfully those sections are set out and they have the corresponding sections in the code which comprehensively deal with what the provisions that need to be made for those individuals are, their expertise and experience, and what their kind of overarching aims are in terms of undertaking that role. So firstly, turn to section 60 of the Act, which deals with the additional learning needs coordinators. There's a duty which means that the governing body must designate a person or more than one person in certain circumstances to have responsibility for coordinating the additional learning provisions for pupils or students who have additional learning needs. And so that individual is going to be termed the additional learning needs coordinator. And under the regulations, which we'll turn to in just a moment, the regulations may require governing bodies to ensure that additional learning needs coordinators have prescribed qualifications or prescribed experience. And they can also confer functions on additional learning needs coordinators in relation to the provision for pupils or students with additional learning needs. So turning firstly to the regulations, just to look at what those prescribed qualifications or experience might entail. So Regulation 27 relates to the governing body of a school, and what those regulations may entail is that the person designated can only be designated if they're a school teacher or if they were formerly a SENCO within the school immediately prior to the 4th of January 2021. And so those are the two circumstances in which a additional learning needs coordinator can be designated at a school within that learning environment. Regulation 28 looks at the prescribed qualifications or experience of an additional learning needs coordinator at a further education institution. And the requirement in those circumstances is that they must be a further education teacher. In relation then to the functions of the additional learning needs coordinator at a school or a further education institution, Regulation 29 sets out those functions of the coordinator at a school, whilst Regulation 30 looks at the same provisions for those in a further education sector institution. So there are a number of these different functions, and they relate in the same way to both those learning environments. But of course, they're relevant then to the individual who's undertaking those activities in either a further education institution or at a school. So the first function they would undertake is identifying a pupil's additional learning needs and coordinating the making of additional learning provision that meets those needs. They'd also be required to secure the relevant services that will support the pupil's additional learning provision. And what the regulations specify is that those relevant services means providing advice or assistance in respect of the additional learning provision, management of the additional learning provision, assessment of additional learning needs, and management of pupils or students who have additional learning needs. So those are the relevant services that the additional learning needs coordinator would need to involve themselves in and ensure are in situ for those pupils who require them. The additional learning needs coordinator would also need to keep a record of decisions about additional learning needs and also the IDPs, which we heard more about last week. They'd be required to promote a pupil with additional learning needs inclusion in the school and access to the school's curriculum, facilities and extracurricular activities. The additional learning needs coordinator would also be required to monitor the effectiveness of any additional learning provision which is made for those individuals, and also with advising school teachers at the school about differentiated teaching methods appropriate for individual pupils or young people who have additional learning needs. They'd also be involved in the supervision and training of school learning or further education learning support workers who work with pupils with additional learning needs to ensure that the provision properly caters for those needs and to ensure that the IDP is maintained. And they'd also be required to contribute to the in-service training for school teachers and further education teachers to assist with the additional learning needs coordinator in being able to carry out their function. So to make sure that there's collaborative working in that regard so that things that need to get done do get done. Turning then to Chapter 8 of the Code, which specifically deals with the role of the additional learning needs coordinator. And so if we think firstly about the mainstream schools and further education institutions, there's a requirement on them that they must designate a person or multiple persons who will have the responsibility for coordinating the provision for learners with additional learning needs. And that those individuals will be referred to as the additional learning needs coordinator, and that will be their role within that setting. Now, some education settings may share the additional learning needs coordinator, and the code gives examples of when that might occur. So it might be where there's a nursery attached to a school, or where there's a number of small settings in a local area, or where several schools are governed under the responsibility of a single governing body. But it also sets out when it's not the expectation that there would be a shared additional learning needs coordinator. And the examples that they give is where it's a large setting, such as a further education institution. But one of the things that the code makes clear is that where there is a sharing arrangement in place, the governing body should ensure that it continues to meet its responsibilities. And so there still needs to make sure that they can fulfil their functions, both under the statute and the regulations and in the code. It's also clear from the code that a governing body should ensure that the additional learning needs coordinator will fulfil their duties in a way that suits the structure and the needs of the education setting and its learners. So it needs to be specific for the individuals with whom it's serving in that regard. The code indicates that maintained schools and further education institutions should consider the skill set and experience of the additional learning needs coordinator to ensure that they can deliver the prescribed functions in law. And the code indicates that the additional learning needs coordinator should be highly qualified and should have expertise in person-centred practice and dealing with a broad spectrum of additional learning need. And there's also a responsibility on their part to ensure that they undertake training to support their continued professional development and to make sure they keep up to date with any kind of developments that occur in their field. The designation of the individual doesn't remove the responsibility of the wider workforce. And so all staff who are working with children and young people with additional learning needs have a responsibility for ensuring that their needs are identified in the first instance and then provided for as well. So it's a whole team effort, but it's coordinated and overseen by the additional learning needs coordinator. The code is very specific that it's very important for the additional learning needs coordinator to have sufficient time and resources to undertake their responsibilities effectively, and indicates that part of this may involve time away from teaching to be able to facilitate that. And it's also clear that the heads of education should support that individual to be able to carry out their responsibilities and to be able to undertake all of the duties that are prescribed to them. One of the things that's very clear in relation to the code is that there's a significant responsibility on the part of the additional learning needs coordinator. And within Chapter 8, it sets out a number of mandatory duties, so things that individual must do. And so I've listed them here and we'll go through them one by one. So the ALNCO has an overarching responsibility for coordinating the additional learning provision for learners with additional learning need. And whilst they're not required to develop every IDP, they do have overall responsibility for ensuring that all learners with additional learning need have an IDP available to them. And they must identify a pupil or student's additional learning need and coordinate the making of provision that meets those needs. They're responsible for securing relevant services that will support a learner's additional learning provision as required. And again, it specifies that they must keep records of decisions about additional learning needs and IDPs as well. Again, it reiterates that they need to promote a pupil or student's inclusion in the community, excuse me, and access to the curriculum, facilities and extracurricular activities. And in doing so, they must have regard to the views, wishes and feelings of the learner and their parents as well. They have a role in monitoring the effectiveness of any additional learning provision. They're required to advise teachers about differentiated teaching methods regarding additional learning need and how to facilitate that teaching. They need to supervise and arrange training of learner support workers, and they must contribute to the in-service training for teachers to assist them in carrying out their functions. So they do have a number of mandatory duties which they need to engage in to be able to carry out their responsibilities under the Act and also with the corresponding regulations and code. There's then a number of what I've called other duties. So these aren't mandatory, but they are recommended within the code as things that the additional learning needs coordinator should be doing. And so these relate to overseeing the provision of information to a learner or to their parent, so making sure that documents and notification of any kind of changes or things that they need to be aware of is done so in a way that's understood by the learner and also their parent. They should be overseeing the day-to-day operation of the education setting, additional learning needs arrangements, and to ensure that there are regular reviews of the additional learning provision made for learners. They should be ensuring that the IDPs are developed and reviewed appropriately, and also that they should also support learners with an IDP with their transition between education settings or transitioning into adulthood, further study or work. There's also responsibility that they should be overseeing the appropriate transfer of information between education settings about the learners' additional learning needs and provision that's being made for them, and that they should liaise with exam officers when seeking reasonable adjustments for examinations, and that they would need to contribute to the development and implementation of appropriate additional learning need procedures and systems to improve outcomes for learners with additional learning need. So there's very much a focus on kind of communication and information sharing to the benefit of those learners to make sure that things are put in place for them in a proactive manner. So for instance, with the exam reasonable adjustments to make sure things are in situ as and when they need to be. The other duties that are specified within the code relate to that the ALNCOs should become a source of knowledge and expertise on additional learning need, and part of that relates to keeping up to date with latest guidance and support available for additional learning need. They're also encouraged to enhance their own professional learning by liaising with a local network of additional learning needs coordinators and other professionals who are involved in this process. So it's to kind of engage in that information sharing and collaborative working to ensure that best practices and guidance on that are shared between individuals, so they can all work to the same high standards. Again, they're encouraged to ensure the record of their roles and professional learning is maintained, and also to provide professional support to all staff and to enable the early identification, assessment and planning for learners with additional learning need. They're also encouraged to ensure that the arrangement put in place by the local authority for avoiding and resolving disagreements are fully utilised as appropriate. Also acting as a key point of contact with external agencies, and these external agencies range from health, local authorities, educational psychologists, independent organisations and social services. There's a vast range of agencies who can be involved and should be utilised where it's appropriate for that individual's prescribed additional learning needs and support provision. And there's also finally a responsibility on them to liaise with career specialists to ensure that those with additional learning needs receive appropriate careers advice. So again, looking sort of to the future, and that comes into then the information sharing regarding transitioning into adulthood and future work, etc. Next, we have the DECLOs, so the designated education clinical lead officer, and this is dealt with in section 61 of the Act. Now it's a responsibility of the local health board to designate an officer to have a responsibility for coordinating the health board's functions in relation to children and young people with additional learning needs. And this individual has to be a registered medical practitioner or a registered nurse or another health professional. But the local health board has to be satisfied that they are suitably qualified with experience in provision of healthcare for young people and children with additional learning needs. Turning then to chapter 9 of the code, which deals with the role of the DECLO. The health board's functions that the DECLO is responsible for coordinating include referrals to the local health board to consider whether there is a relevant treatment or service likely to be of benefit in addressing a learner's additional learning needs. They're responsible for securing the additional learning provision described in an IDP which is required by the local health board to provide. They're also required to participate in reviews of IDPs as and when they're part of that process and part of that facilitation of additional learning provision. The DECLO is also required to comply with requests from local authorities for information or any other help when involved in the additional learning need process and facilitating that. The DECLO is also involved in informing parents and local authorities of the local health board's view if they consider that a child is likely to have additional learning needs. And so they need to be proactive in that regard. If it comes to their attention, they have a responsibility to ensure that the relevant organisations are informed. There's also responsibility on the DECLO for giving evidence to the tribunal in an appeal regarding additional learning needs matters if the health board is involved in that. And the DECLO is also involved in dealing with recommendations by the tribunal to the local health board if it relates to the functions of the local health board in that process. Now, in terms then of the experience of the DECLO, the code prescribes what the type of experience that would be desirable in the circumstances would be. And so what the code says is that the local health board should ensure that the designated officer has experience of senior health service leadership, that they're capable of providing overall strategic direction to ensure the local health board meets its duties regarding additional learning need, that individual is able to identify and solve problems and conflicts at the earliest opportunity, that they're able to escalate issues to the local health board's executive board if that's an appropriate course of action, and that they have experience at a senior level in an aspect of healthcare which is relevant to the additional learning needs. In terms then of the role of the DECLO, it's clear that this is a strategic role that should include the following responsibilities. And so what the code says is that they're involved in collaborating with others. And so again, this comes back to the sharing of best practice guidance to ensure that everybody is working towards the common goal, that they're involved in raising awareness of the additional learning needs system across the local health board, that they are responsible for managing efficient and consistent systems within the local health board to enable it to exercise its statutory functions, that they're involved in managing the local health board's involvement in complaints, disputes and appeals relating to the local health board. And they're also involved in measuring the compliance and quality assurance of the local health board activities. So they have quite a wide-ranging role and fairly significant responsibilities in that regard. And it's important, of course, that they're aware of all aspects of their role and what it entails when being appointed in that position. So the third professional we're going to look at is the Early Years Additional Learning Needs Lead Officer, or the ALNO. And this is under section 62 of the Act. And so what that says is that a local authority must designate an officer to have responsibility for coordinating the authority's function under this part in relation to children under compulsory school age who are not attending maintained schools. And it also says that individual is to be known as the Early Years Additional Learning Needs Officer. The relevant chapter in the code is chapter 10. And what this says is that the local authority is responsible for designating that officer, and what the ALNO is responsible for is coordinating the following local authority functions. And so part of that role is deciding whether children have additional learning needs and preparing and maintaining the IDPs and providing information about those IDPs. They're also involved in the review and any kind of revision to the IDPs, and also the review of additional learning provision arrangements. They're also required to be involved in making arrangements, provide advice and information to parents and case friends of children in this area, and also involved in making arrangements for the avoidance and resolution of disagreements. Finally, they're also involved in making arrangements for the provision of independent advocacy services. And so again, they do have a number of functions which they have to carry out to ensure that the local authority meets its statutory duties. In terms then of the experience and expertise of the early years ALNO, this again is set out in chapter 10 of the code. And what the code says is that the ALNO should have experience and expertise in relation to working closely with children who are under compulsory school age, who have additional learning needs, and also with their families. They should be experienced in dealing with the provision of services for meeting the additional learning needs of these children across a wide range of settings. And finally, they should have expertise in nursery education or child development. Similarly to the Health Board, the local authority should only designate an ALNCO, an officer it considers capable of delivering the expectations of the role. So again, similar to the DECLO, it needs to be someone who is suitably qualified. The designated individual should be capable of providing overall strategic direction to ensure the local authority meets its statutory duties, and also be able to act as a source of expertise for providers of childcare and non-maintained nursery education. So they have a key role in strategic direction and also as a source of expertise in terms of advising and assisting other organisations to ensure that they can meet their role and their duties. So then looking then at the role of the early years ALNCO, there's two elements to this. The first being an inward facing role. And so what that effectively means and what the code says is that this individual should have overall responsibility within the local authority for ensuring that there are appropriate arrangements in place to ensure the local authority is able to perform its statutory functions. And so it's got that overarching responsibility to make sure that the arrangements are there such that the local authority can do what it needs to do in accordance with the Act. And so what that means in kind of practical terms is establishing and maintaining efficient structures and systems regarding resources, decision-making, interventions, IDPs, information sharing and dispute resolution. So putting in place those kind of structures to make sure that all of those things can be maintained and dealt with in accordance at the earliest opportunity for that individual. They're also involved in strategic planning and allocation of resources, budgets and funding. And they've also got a requirement to be involved in the development of policies within their field and for that local authority. The second side of their role is the outward facing role. And what the code defines this as is they have a pivotal role in facilitating the early identification of additional learning needs. And part of that requires collaborative working with the local authority professionals, general practitioners, health visitors, social services, organisations like Families First. There's a whole host of organisations which the code specifies and these individuals should be working with to try and facilitate the early identification of additional learning needs and to work closely with them to enable them to perform their duties. Part of this outward facing role also relates to raising awareness of the additional learning needs system kind of across their locality. And the local authority should expect its ALNCO to be a source of advice and expertise on additional learning needs and the additional learning needs system and its application to the relevant cohort of children in the circumstances. So just, I suppose with the key points to take away, of course, there's a lot of information, and one of the main things really coming out from the code, certainly in the Act, is that the designated individuals, the Additional Learning Needs Coordinator, the DELCO and the Early Years ALNCO have considerable responsibility for ensuring compliance with statutory functions regarding additional learning needs and additional learning provision. There's a focus on working collaboratively between professionals to ensure that additional need is identified promptly, that information is shared as required, and that additional learning provision is provided in accordance with the identified needs. The educational professionals are involved in strategic planning, budgets and advising on policies, and the code does specify what desirable expertise and experience those individuals should have to enable them to carry out their functions in accordance with the Act and in accordance with the regulations in the code. The code comprehensively sets out the roles and responsibilities of each of those professionals, in addition to the prescribed expertise and experience. And helpfully it sets out what must be done by those individuals and what should be done. And it does make the distinction that there are some mandatory duties which have to be done by the designated individuals, whereas there are some which are shoulds. So they're desirable, but they don't have the same weight as the mandatory requirements. That concludes a whistle-stop tour of the education professionals and what they're required to do under the new Act, Code and Regulations. Thank you very much for listening. I'm going to stop sharing my screen now and hand over to Abla, who's going to talk to you about the impact on parents.
Hi everyone, thanks Melissa. So yes, as Melissa said, I'm Abla and I'm a public law barrister at 30 Park Place. In terms of my education background, it involves a range of special educational needs, but also exclusions, admissions, and universities as well. And before I start, I also wanted to extend my thanks to Kat Jones, who's a pupil at our chambers, who provided invaluable assistance in relation to these presentations as well. So now I am going to hopefully successfully share my screen. Oh, I think I might have shared impact on health bodies instead of impact on parents. One moment, please. They look very similar from far away. I'll try again. That should hopefully be the impact on parents one, but it keeps turning up as the other one. I'll exit my impact on health bodies one because I think the PowerPoint is getting confused. So just bear with me one moment. Let's try again. That should hopefully now finally be the right set of slides. So yes, I'm going to be speaking on the impact on parents and particularly in relation, firstly as an overview, I'd firstly like to highlight that the word parents is used quite interchangeably throughout the references that I'll be making to children, parents or young people, particularly in relation to the duties that I'll be talking about. And similarly, quite often when I refer to local authorities, that's usually referred to in combination with maintained schools and further educational institutions. So for the sake of brevity, whilst I'm giving the presentations, I might just say local authorities or I might just say parents, but of course there might be other references to others as well. So firstly, just by way of overview, when there is a duty to make a decision about whether a child has additional learning needs or to prepare a review or reconsider an IDP, there's clearly the obligation to support the parents to understand the process and the decisions which are made. And the broad ways in which this should be done is in relation to explaining from a very early stage at the outset the way that parents can understand the decision that the body is making, the process for making it, and how they can also contribute to that process. A second aspect is when there are meetings to determine the additional learning needs and prepare the IDP or any other meetings in terms of review or reconsideration, then it's important to explain what is being proposed. And that relates to, for instance, explaining the additional learning needs, the proposed provision, or the outcomes for the child. In a way, and it's important to highlight that this should be done in a way that individual parents can understand, which is an aspect that I'll be going in more detail on shortly. So the duty to parents. So there are general duties in the code. And of course, given that this is a presentation that highlights the main aspects, we won't be going through every single one, but there are general duties to receive documents and notifications of decisions under the Act, which is of course not dissimilar from duties and rights that have previously been in place, and also rights to engage in meetings and dispute resolutions, but also to take appeals in their own name. So there are requirements throughout the Act as set out in bullet points on the slide to notify a child's parent of something or inform them of something, give them particular information, or give them a copy of an IDP or revised IDP. It's highlighted there that if a child's parent lacks capacity when a requirement imposed by the code to do any of the matters just listed fails to be complied with, then what it needs to be read as is that the reference to the child's parents is reference to the parent's representative in that particular circumstance. And the requirements of the code, it's stated that they must be interpreted in that way. Now, in terms of participation of children, their parents, and young people. So a person exercising functions under the Act, for instance, a local authority, must, under Section 6 of the Act, have regard to the views, wishes, and feelings of the parent, child, or young person. It's also highlighted that participation and the importance of encouraging and enabling them to participate as fully as possible in relation to decisions that relate to the exercise of the function concerned, but also that they are provided with the information and support necessary to enable them to participate fully in those decisions, which is another aspect that we'll be going into in a slightly more detail shortly. In terms of these particular aspects, the duty gives effect to the rights that are set out in the United Nations Convention on the Rights of the Child, and also the United Nations Convention on the Rights of Persons with Disabilities. This is an aspect which I'll be going in a bit more further detail within my health bodies talk, but also there's more guidance on those particular aspects as to the conventions in Chapter 5 of the Code. What's important to highlight at this stage is something that Melissa's referred to as well, is that what's being promoted is a person-centered practice, which puts the child or the parent or the young person at the center of decisions. And the code does highlight that there's a range of resources which support practitioners in using person-centered practice approaches. And that is also available online. I think there's reference to that, or how you can access it, at page 43, if you wish to do so. This duty that is set out in the slide, it applies irrespective of the capacity of the child or young person. So for instance, even if a child lacks capacity to understand what it means to exercise the rights under the Act, their contribution to the process is important, so that the needs are correctly identified and that the provision is in place, which is effective at meeting their needs. So that's still an aspect that needs to be looked at fully, even if they lack capacity. And further information on that is at Chapter 30 and 31 of the Code, if you wish to look into it further. So in terms of supporting parents in particular, there is a duty to, of course, to involve young people and children, but it also applies in the same way to involve and support the parents of children. And their right to participate in decisions is highlighted particularly as that is of course something that would make a difference in terms of better decision making, and it's highlighted that a positive attitude is adopted in relation to that in order to ensure that there is that better decision making and better outcomes for the child. There are, of course, specific requirements throughout the Act to give notification or information to parents at particular points, or to discuss particular matters with them. So in terms of the duty in practice, so there's a should aspect here, obligation for local authorities when making decisions about a child or young person's additional learning needs, provision, or other matters relating to the IDP, to firstly seek the child, parent or young person's views on how they wish to participate in decisions ahead of those decisions being made. So obviously the emphasis there on the early anticipation of seeking those views, but also providing them with information that's relevant to the decision, but not just providing it, but also providing it in a way that the parent or the young person is able to understand it. And of course, communication with them about what assists and how they would best be able to receive that information is important. There's also the importance of encouraging them to participate fully and finding out how that could be enabled by using their views to inform the decisions, and ideally, obviously, and of course, what would be very useful is evidencing how that has happened. And also ensuring that they have access to information about their additional learning needs and about the system itself. So from these aspects, in terms of this duty in practice, you'll note that it's important to do things at an early stage in the process for making such decisions, but also to continue to do them during that process as may be necessary. In terms of understanding the child or young person or parent understanding what's going on or participating fully, it's important to consider how they would like to communicate and participate, but also to consider the suitable means of engagement for them and how to support them to participate. So that can include a whole range of things, including the language of communication, the means of communication and engagement, in the case of young people, whether and how they wish to involve others in those communications. There's particular reference to the Children and Young People's National Participation Standards, and those are referred to in the code, but can obviously be looked into further. And it's said that they provide a guide to listening and responding to the voices of children and young people. So if that aspect to be explored further, that would be a helpful reference to delve into. Sorry, excuse me. The next aspect is about providing information and support. So where a maintained school, further educational institution or local authority is making a decision as to whether a child or young person has additional learning needs, there are requirements on it to do various things, which are set out in detail, chapters 11 to 17 and 18 of the code. But they include notifying the child and their parent that it is deciding whether the child has ALN and considering whether to offer a meeting to the child and their parent or young person. But further, it's set out also that at the outset, the process should be explained, and a meeting that would be actually a helpful way of doing that, which I'm sure is a common practice a lot of the time anyway, but there's quite detailed guidance on meetings within the code at chapter 22. And it's particularly highlighted that, for instance, there may be situations where children and young people with additional learning needs may become anxious in the face of new or unfamiliar situations, or they might feel overwhelmed or uncomfortable. And this may, of course, affect their ability to fully participate or express their views in relation to such decisions. And that could be in situations where there are meetings where there are a large number of adults, for instance. So in those certain sorts of circumstances, there needs to be consideration about how to involve them or gain their views, whether by partially participating in a meeting, for example, or meeting with some of the members that will be present at the meeting rather than with everyone being present. But what's also highlighted is that there may be situations where it's not appropriate for a child or young person to be present in a meeting, generally, for instance, if they're too young to do so. But what's important is that their wishes and feelings must still be taken into consideration. And it's important that those are taken into consideration and ascertained in advance of the meeting so that they are then utilized within the meeting and taken into account. And so what should happen in those situations as well is that an appropriate person should explain the process to the child or young person in a way that is appropriate for their age or understanding, and seek their views as well. Their wishes and feelings should also be recorded in the relevant section of the IDP, of course, depending on the matter to which those particular wishes and views relate. Consideration needs to also be given to supporting parents, of course, in terms of, for example, some parents may require support that goes further than signposting to information and advice if they have any difficulties with accessibility or understanding. Or, for example, they might wish to receive information in a format that is accessible to them. So it's important that that format is ascertained in advance, whether it's post or email or whichever might be more accessible to them. Similarly, some parents, there's reference to some parents needing support to see their children as partners in decisions relating to education, and in those instances as well, support and encouragement for the parents to overcome those difficulties and ensure the full participation of the child in those sorts of circumstances as well is really important. There's general references to, for instance, when the meeting is for a maintained school or a further educational institution or a local authority to decide whether a child has ALN or to prepare the IDP, that the designated coordinator should be responsible for arranging the meeting, and they should lead it. And that's similarly when reviewing the IDP, it should be the person that's responsible for conducting the review, who is responsible for arranging the meeting and who should lead it. But for other meetings, they may be arranged and run in other ways. But of course, what needs to be taken into account is a really important aspect, is that the approach has to be appropriate to the circumstances of the child and young person. And an example in relation to that is that, for instance, the ALNCO might need to involve a teacher who knows the young person better to take the lead in communicating with the young person at that meeting, if that would assist. But of course, as I've said, there's further guidance on that in chapter 22 of the code. There's just general reference here to how local authorities should involve children, parents, and young people in designing or commissioning arrangements for providing information and advice about ALN and about the ALN system, and that this can, for instance, be done through participation workshops or focus groups. And the effectiveness of the local authorities' arrangements should be informed by that regular feedback from the users, which of course should be considered with a view to improving that service. So that's another way in which parents, children, and young people can be involved in the process, as it also assists to ensure that the advice and the information is easily accessible to them, and that the arrangements meet their local needs. And it's something that would also assist in avoiding and, for instance, resolving disagreements, which is the next topic I'm about to touch on now. So there's an obligatory must for local authorities to promote the arrangements for avoiding and resolving disputes. And one method is to ensure that they receive the details of these arrangements at the earliest stage, and when they receive notice of a decision by the local authority. They should also be promoted and publicized more generally at earlier opportunities. So for example, at early meetings to discuss a child or young person's additional learning need. And you'll note that there's a particular focus on anticipation and providing these options and ensuring participation at a very early stage to avoid or reduce the chances of disagreements escalating. So the other aspect is that local authorities must take reasonable steps to inform children, their parents and young people that entering into disagreement resolution arrangements does not affect any rights they have to appeal to the tribunal. And that information about the arrangements should be available on the local authorities' websites, and it should be available in a format that is easy for anyone to easily be able to understand, for instance, by the use of plain language. It should also include information as to how they can access the arrangements, such as providing a point of contact, a telephone number, and an email address, for example. Here what's set out here is a list of matters which can be appealed by parents. I won't read through each one of them, but set out in the section 70 of the Act. And of course, you will have access to the slides, so you can go through them in more detail if you wish to do so. But it's just a list of the different aspects which can be appealed by the parents. And this continued here on the next slide as well. A brief point here that there can be appeals by children in terms of children bringing their own appeals to their tribunal if they have sufficient capacity or understanding to do so. So where required, the tribunal can make decisions about a child's ability to understand matters relating to the ALN system. And also children who lack capacity can still bring an appeal to the tribunal in their own name with a case friend to represent, support, and take decisions on their behalf if it is a situation where they do not have a parent who is willing or able to bring a case to the tribunal for the child. And there's further information on that at chapter 30 of the code. Also here briefly, applications for a declaration for a child who lacks capacity. So a child or a child's parents may apply to the tribunal for such a declaration. What's set out is the information or documents that are required are to be given to the child under Part 2 of the Act. Or, for example, if they don't have capacity to understand what it means to exercise the rights conferred by Part 2. So a child or child's parents seeking a declaration from the tribunal must submit an application in writing to the tribunal. So that's obligatory under Regulation 59(1). And in that instance, the Educational Tribunal will then provide the relevant application forms once those are requested. So thank you very much for listening. That concludes my talk on the impact on parents. And I'll now hand over to Mr. Michael Imperato.
Thank you, Abla. I hope everyone can hear me okay. I'm Michael Imperato. I'm kind of the odd person out here because I'm not a barrister at 30 Park Place. I'm a solicitor at Watkins & Gunn, but for many years I've been doing cases for children and young adults with special needs at ALN. So I'm going to talk about further education, and I'm going to attempt to share my screen. There you go. Well, we all know where we are. The ALN code was, of course, recently approved by the Senedd, and we can now, it's now going into the implementation phase, which is still going to take a bit of a while though to go through. A Coleg Cymru ALN transformation lead said that ALN colleges have been really enthusiastic about the transformation. FAI staff have embraced the changes and confident that they'll provide a first-class service for all their learners. So that's encouraging. Of course, the bedrock of all this is the IDP, so I'm not going to go into that in great detail, at all. You should all know what we're on about with that. But that's just a kind of classic definition of it. One of the things is I'm trying to pick out the key issues for education institutes, and clearly they must have a system. We have the kind of transition phase, so they need to check and see if new students are likely to be caught by the code. So most of my references are from the code, actually, which the code, of course, gives us really the detailed route maps of how to do these things. So it's 2746 says an FEI should provide young people at the time they're enrolling with an opportunity to raise any ALN they have. If the young person does not have an IDP, the FEA might be under a duty to decide if they have ALN. If they have an IDP, if they're arriving at the college with one, then obviously it's important they know about it. The FEI may be required to maintain it. It's under a duty to help the local authority to secure the additional learning provision. Quite obviously, if a young person has an IDP in school and moves on to an FEI, then when they become enrolled as a student at an FEI before the end of the September in an academic year, the FEI must maintain the young person's IDP if they were a registered pupil at a maintained school during the previous academic year, and if that school was maintaining the IDP. So basically, this is intended to capture a young person moving from a maintained school to a further education institute at the start of the academic year. It also works at the end that when a person is leaving educational training, there should be a kind of a way of discussing what they're going to do next, what happens when the IDP ceases, advice about agencies and support going forward. So there's supposed to be help you're supposed to be able to capture the person's learning needs at the beginning and to help them on their way at the end. What I think is interesting, it doesn't matter how the possibility that a young person may have ALN has been brought to the FEI's attention. So the FEI should, on or around the student's arrival, provide an opportunity to raise any ALN and must maintain an existing one. So therefore, the FEI, you have to have a system to capture all this when people are arriving at the college. And if you fail to spot that an IDP is in place, you could be facing a significant legal challenge down the line, because maintaining the IDP is a must. Trying to spot whether a pupil has ALN, or to give them the opportunity, is a should, but it's a must that you must maintain the IDP. But it doesn't stop there. Section 11 of the Act says that that when it's brought to the attention of or otherwise appears to the governing body of a school or FE college that a young person may have ALN, the school or college must decide whether the child does indeed have ALN. So I think otherwise is an interesting word, as I say. It must mean that the potential to ALN does not have to come from the student, but should be picked up in any event. So how is that done in practice? So it's not all on the student or all on the student's previous institution to flag it up. You have to have your kind of antenna out to meet the otherwise point. All this, the implications of all this, then, so trying to kind of capture the new students, whether they have IDPs, whether they should have an IDP, what their ALN situation is, their opportunities to raise the issue with you, all that equals resource, cost, expertise, training, communication and engagement with students, and there could be legal issues arising from it all. The duty to decide if ALN does not kick in, and there's a couple of examples there under 16.4, but paragraph, the ALN process sets out the role of a designated coordinator. There's a lot of guidance on the issue of young person's consent and engagement. That's clearly a very important aspect to all this. There's then, this is the code talks about drafting the IDP, and but the FAI must maintain the IDP. If you don't maintain it, potential JR challenges, of course, could apply. Again, that means more resource, cost, expertise, training, communication, and legal issues arising. Involving the local authority, if the FEI decides that a young person has ALN, they may refer to the local authority. Basically, we're talking about here if it's quite significant needs. The FEI should be mindful of the needs to make any such referral as early as possible. The circumstances of the college could affect their view on whether it would be reasonable for it to secure the ALP. So really the kind of background and the situation of the college. So that seems to me quite a subjective, requirement, and maybe something that's quite ripe for argument. Where the FEI refers the case of a young person to local authority, it should consider what information to give the local authority. Does that give rise to data protection issues, I wonder, about consent? Because the Further Education Institute and local authorities, they're separate bodies. So is that a concern? Is that an issue about what information is being transferred? So where there's a referral, where involving the local authority, where a referral is made by a FEI to a responsible local authority, the local authority must decide whether or not the young person has ALN. And again, the code deals with the procedures on all that. The local authority decision to refuse can, of course, be appealed by the young person to the tribunal. And I raised the question, would it be in the interest of the college to support this? The college is saying, really, this person has significant needs, which can only be met by help by the local authority. Would it be in the interest of the college to help support an appeal in that respect? The local authority may request the college to become responsible for maintaining the IDP, so it can be effectively bounced back. The transfer of responsibility, the transfer of responsibility under section 28 of the code, there's a range of circumstances where local authority may come to be maintaining the IDP for a young person enrolled as a student themselves. So that's the kind of almost an obligatory requirement of the local authority to take over the IDP. But also where a local authority under 2823, where a local authority maintains an IDP for a young person who is or becomes an enrolled student at an FEI, the local authority may request that the FEI becomes responsible. So they may, as I say, they may bounce it back. Then the matter, if there's basically a total breakdown between the college and the local authority about who is responsible, the local authority may refer the matter to the Welsh ministers, where the referrals be made to them by a local authority. The Welsh ministers must determine whether the college should maintain the IDP. What happens if you don't like what the Welsh ministers decide? How do you challenge the Welsh ministers if you're the college and you think this is still wrong, presumably by judicial review? But there's not a lot of information on this bit of the process, even though it could be quite important. Again, implications of resource, cost, expertise, training, etc. I wanted to touch very briefly on post-16 education and specialist for the colleges. In Wales, that's still set out under the Learning Skills Act. And this means that the Welsh ministers have to ensure that a residential placement is obtained. So at the moment, you can have the Welsh government funding residential placement in specialist further education institutes. And the assessment at the moment is carried out by Careers Wales, and it's called a Section 140 assessment. I ran a case on all this a few years ago, DJ and the Welsh ministers, looking at how this was working, and we made some challenges about how the process was working. In the act, though, the intention is to transfer the responsibility to local authorities, and there's a set of regulations set out, which then says that the Welsh Minister establishes a list of basically specialist institutions and sets out what these institutions have to do to be on the list. And local authorities will only be allowed to fund if you're on the list. If you're not on the list, you can't come in, as the phrase goes. So Careers Wales will provide advice to will continue to provide advice. However, their role of undertaking the assessments will no longer be required. The Welsh Government is in discussions with people about reallocating funds because of course a lot of the funding is going to have to come from the local authorities. But at this time, it's not proposed for that funding to be ring-fenced. So it won't come in yet. The Welsh Minister system still applies, but this will apply. I think I've read it in 2022, although I've been told by people in the field 2023. So as I say, at the moment, as we speak at the moment, we'll still have the current system for specialist further education funding, but it's going to change, and it's going to be to a large extent put down onto the local authorities to deal with as we go forward. So specialist further education institutes may have a number of concerns about that, concern about the list, of concerns about funding not being ring-fenced. I'll touch briefly on appeals. Of course, we are having the new regime, which Mark will be talking about in some detail shortly. But the point is, a young person may appeal to the tribunal of decisions of further education institute, maybe not to give them funding and the like. So that is so further education institutes are going to be in play in the new in the regime with the education tribunal. And it will not be just as to whether they should have an IDP or not, or it could actually be about what an IDP states. IDPs do not necessarily have such high thresholds as the old-fashioned statements, so expect more room for disputes, not less. So I consider that the further education institutes are going to be visiting tribunals, possibly quite regularly. And the reason for that is that, of course, they're going to have given students lots of information about their rights and about ALN at the start, so their students are going to be empowered to think about taking appeals against further institutions, against the colleges. You're going to have disputes. Abla touched on some of this, so it sets out about how the local authority has to have dispute resolving mechanisms, so those dispute resolving mechanisms lie in the hands of the local authorities, but further education institutes must clearly have a stake in that, because clearly the colleges would like a good dispute resolving process. They have to provide information and support about the challenge, about how to challenge themselves. So I think it's important that colleges are having a kind of joined up discussion with local authorities and the like about the dispute resolving processes, because the colleges are going to get immersed in it. So again, that's resource, cost, expertise, training, communication, engagement, and legal issues arising from all that. So sorry, that's a kind of a whistle-stop tour through it all, but I think what I'm trying to say is that at the beginning of the process, at the beginning of the student's journey into the college, at the end, and throughout their journey, there's going to be a lot more interaction for colleges, room for disputes between colleges and local authorities, between local authorities, colleges, and Welsh ministers, and various opportunities and avenues for appeal. So I think there's going to be a big changing landscape for further education institutes, and there's no way around it. They're going to have to put in resources and expertise, training, etc., into those. Right, thank you.
Thank you, Michael. I think it's my turn now to deal with the impact on health bodies. And I'll try and be as brief as I can because I'm conscious of the time, and also Mark is going after me in terms of the final talk today. So I'll try and summarize as much as possible, and then you can refer to the slides after today. So hopefully you should now give you on the impact on health bodies slide, which this time has opened correctly. So this is just the background in terms of the overarching aims of the Act, which was addressed last week in any event about the unified legislative framework, the collaborative process of assessment, and a fair and transparent system. But that's just a summary of some of the main overarching aims. I've referred here to the United Nations Conventions, which I referred to briefly during my last talk on the impact on parents. And in relation to those two conventions, the principles are given effect within the Act and the Code, and therefore, in exercising their functions under the Act and in compliance with the Act, local authorities and NHS bodies are likely to be giving effect to the relevant rights under the conventions anyway. But notably, the local health board should ensure that the DECLO is aware of and takes action as appropriate in compliance with the duties and having regard to those conventions. So what's notable also is that there is a specific consideration of the convention on each occasion a function is exercised. So that's not the requirement. Rather, what's required by NHS bodies and local authorities is that they must have due regard to the conventions when they're planning generally for the exercise of functions under the Act. And there are further examples in relation to that within the Code. Melissa has addressed you on DECLOs helpfully, so I won't be going through that again, but it's useful to have it there within the slides that relate to health bodies in relation to what the key roles for the local health board would be and what requirements must the DECLO have in terms of experience and background. So it's set out there again for ease of reference as well. Similarly, this aspect was also touched on by Melissa, so I won't repeat what is on that slide, save as to say that in relation to the role of the DECLO being a strategic one, particularly in relation to collaboration, and as it relates to health bodies, the local health board should ensure that the DECLO works in partnership and cooperates with others, such as the early years, ALNCOs and the ALNCOs, as well as service users. And this comes back into the whole promotion of collaboration and effective multi-agency working between the health service, the public health, local authorities, advocacy services, schools, further educational institutions, and the third sector. So the role of the DECLO should be involved in that collaboration aspect as well. In terms of multi-agency working, so there can be statutory requests for help by a local authority or by others, but in terms of the local authority in particular, there is a duty from the relevant person, so that could include a local health board, an NHS trust, the National Health Service Commissioning Board, a clinical commissioning group, an NHS Foundation Trust, or a special health authority. So those are all examples of what can constitute a relevant person. So there's an obligatory duty to respond only where it applies to the local authority making the request for information or other help. However, schools and further educational institutions may still make requests for information or other help for the purpose of exercising their functions relating to additional learning needs. And if the relevant person responds to the school or further educational institution, even though they don't have a duty, a must duty to respond to them, it can mean that the matter can be dealt with more quickly and without having to involve the local authority in that situation. So in terms of complying with the requests, there's a must duty to comply with it unless it's considered that doing so would be incompatible with its own duties or would otherwise have an adverse effect on the exercise of its functions. So if an RP decides not to comply with the request, from the LA in particular, the RP must give the authority written reasons for that decision. And the response should be made promptly and in any event by the end of a period of 6 weeks from receiving the request, unless it's impractical to do so due to circumstances beyond its control. And if that's the case, the expectation is that there should still be a response setting out the reasons for the inability to respond within that time frame, and also indicating what the expected time frame would be for providing that response. In relation to situations where the additional learning provision is secured by NHS bodies, this is particularly in relation to additional learning provision that is something that would be normally provided as part of the health service in Wales. So a local authority or a further educational institution may make a referral, but it must not make that referral to an NHS body unless it's informed the child or young person that it intends to make the referral and given them the opportunity to discuss whether the referral should be made. And finally, is also satisfied that making the referral is in the best interests of the child or young person. So there must also be a consideration, and I think this was touched on by Melissa as well, in terms of whether there is a relevant treatment or service that's likely to be of benefit. And if so, it must secure the treatment or service for the child or young person. So again, obligatory. I must decide whether the treatment or service should be provided to the child or young person in Welsh and take all reasonable steps to secure it. Including if it decides that the treatment or service should be provided in Welsh. There's also an obligatory duty in relation to informing in relation to the outcome of its consideration. So the NHS body must do so promptly, like I said, in any event before the end of a period of 6 weeks. So to support this process, the body responsible for maintaining the IDP, like for example, the local authority, should send the NHS body a template in which the NHS body can describe what the additional learning provision is that it has identified. There is a template within Annex C of the code for reference purposes. Here I've referred to if there's a description of provision, it must not be removed from the IDP or revised except on review of the IDP and with the agreement or at the request of the NHS body. This is of course referring to provision that the NHS body is providing or securing. Further, the NHS body may request a review at any time, and if it does so, the body maintaining the IDP must review it. But on the other hand, if on review the NHS body requests the responsible body maintaining the IDP to remove or change the description of the provision that the NHS body must secure, then the school or local authority, etc., that maintains the IDP must comply with the request to remove or change the description of the provision within the IDP. So just a few pointers in terms of the IDP in particular. In relation to identifying ALN in children under compulsory age, it's particularly notable in relation to health bodies, as it's noted that health professionals such as pediatricians and health visitors often come in contact with a child before educational professionals do, and therefore they're in a position to identify potential additional learning needs before anyone else. And so in that kind of situation, where in their exercise of functions in relation to a child under compulsory age for whom a local authority is responsible, a health board forms an opinion that the child has or probably has additional learning needs, it must inform the child's parents of its opinion and also of its duty to bring this to the attention of the local authority. Further, it must give them the opportunity to discuss this with one of its officers. And if upon discussion, the health board remains of the opinion that the child has or probably has additional learning needs, and it is satisfied that it's bringing it to the attention of the local authority would be in the child's best interest, then it must do so. And in terms of the best interest consideration, that's a matter for the health board in the particular situation and circumstances, but there are relevant considerations and examples that are set out at 21.17 of the code. And particularly there's reference to discussion with the parents being an opportunity to explore whether there are any countervailing considerations, as well as to ascertain the parents' views, which obviously also feeds into whether that has any impact to the opinion being reached or aspects in terms of best interests as well. There's also the obligation to inform parents of any voluntary organizations that are likely to be able to give advice or assistance if that's applicable in a particular case. In terms of resolving disagreements, if a matter relates particularly to a health service or health, whether it relates to an assessment, treatment or service provided by the NHS, then the local authority should refer the child's parent or the young person to putting things right, which is an arrangement for the management of concerns and complaints relating to the NHS in Wales. There may be situations when the local authority and the DECLO could work together to make arrangements to attempt resolution. And in those situations, you could use both the putting things right and the arrangements that are made by the local authority. However, it's particularly noted that where advocacy or support for the child, the young person or the family member is required, then this is often more effective when it's undertaken by a single individual. So that's referred to advocacy, that's in reference to advocacy or support by the child. But that's the putting things right, which particularly relates to NHS body and health issues. There are a number of alternative routes of appeal and complaint resolutions. Again, for the sake of time, I won't be going through each one, but it's listed out there, the different options that can be gone into in terms of appeal, complaints or dispute resolution. In relation to tribunal considerations, the tribunal may require an NHS body, if there's an appeal under Part 2 of the Act, to provide evidence about the exercise of its functions and make recommendations to the NHS body. So what's to be highlighted there is the tribunals making a recommendation to the NHS body about the exercise of its functions. And if it does so, then the health body must report to the tribunal before the end of 6 weeks from the date on which the recommendation is made. And it must state the action that it's taken or proposes to take, or why it is not taken or does not propose to take any action in response to that particular recommendation. And in this particular regard, and in other regards that I've referred to as well, DECLOs are the main point of contact in terms of coordinating the local health board's involvement in appeals to the tribunal. And the health board should expect the DECLO to be responsible for leading on the health board's consideration of recommendations made to it and deciding whether and what action to take in response to those recommendations. It should also be the DECLO that is reporting back to the tribunal. In terms of revision of an IDP, again, just a couple of pointers. If there is a situation where the tribunal orders the revision of an IDP in relation to a provision that is specified as provision that the NHS body must secure, the NHS body is not required to secure the revised provision unless it agrees to do so. So in that situation, so the body maintaining the IDP, for instance, the local authority, is expected to work with the NHS body to see what agreement can be reached and to explore further what can be provided. Thank you very much. I'll now pass on to Mark. I've just set out there my email address or the clerk's email address if you have any further questions today. Thank you.
Thank you very much, Abla. Let me just share my screen now. Right. My talk is about the Education Tribunal regulations principally, with one or two references to the code and of course to the Act as well. First of all, implementation. Just see if I can get rid of that. That's better. The application to appeal or bring a claim after the 1st of September 2021 means you're on to the new regulations, and that appears to apply whether that is a statement or an IDP that is being appealed, although of course the statements will gradually disappear as time goes on as per the implementation. But there will be two schemes running, as we all know, for about 3 years, but it seems that they're all going to be dealt with by the one set of tribunal rules. This is you all trying to get ready for implementation, realizing that time is running out, which it no doubt is. And I know there's been some discussion about quite how it's all going to be implemented again, which I'm sure will be ongoing. A reminder about the overriding objective. This is what guides these regulations, and therefore I make no apology for repeating it just so that everyone is fully aware of it. The tribunal panel of the president have to deal with claims fairly and justly, you'll be pleased to know. And what that means is, it means dealing with the appeal in a way which is proportionate. Proportionality, of course, has become a watchword for most courts and tribunals, so that parties can't go on ad infinitum about an issue. The tribunal will try and manage it so that it's proportionate to what is actually being discussed before the tribunal. It also means trying to make sure there's not unnecessary formality. The legal representative turned up in a t-shirt yesterday at a hearing, being an exception to quite how far we're prepared to go. Also ensuring the parties are on an equal footing. So sometimes assisting someone in particular who's in person, and that may be, of course, a head teacher from a school in a claim, as well as a parent in person. But if they need a bit of support and help, the tribunal should try to do that so long as it can do it fairly. And also the tribunal has to use its expertise appropriately. And last of all, of course, it has to avoid delay. Now, that overriding objective has to be uppermost in the president and the tribunal panel's thoughts throughout. And everything that's done in terms of exercising any function or interpreting a regulation, and the latter is particularly important, I think, because it means there's a purposive method of actually interpreting the regulations, has to go back to the overriding objective. And all of the management of tribunal hearings has to be with that in mind as well. Now, what does that mean to the parties at a tribunal? And this is something which is still honoured in the breach, but I hope will stop being honoured in the breach. The parties must cooperate with each other for the purposes of progressing the appeal or the claim, cooperate in the exchange of documents or information with each other to enable each party to prepare a case statement. So being difficult and bolshy and not giving papers to the other side, or not giving expert reports in particular till the last minute, should not be happening. And the parties must help the president or the panel to further the overriding objective. And that means partly cooperating with the president and the tribunal panel generally. I do hope this is going to be looked to rather more in the future, because there are still occasions when I know that legal representatives and parents on the one side or local authorities on the other will think that the other side is not cooperating, and I wish to say that that should stop. And there are sanctions if there is non-cooperation. The tribunal panel can draw inferences as it thinks fit, and once it's drawn one, they can direct a notice to be served that the party in default, so either side, can have their part of it struck out. So it's pretty draconian stuff, and as you can see, it can be the appellant, the claimant, or indeed the local authority or responsible body. A word about case statement periods now under these new regulations, because here there is a change as I read the regulations. Regulation 17 says the case statement period for the appellant is the relevant period of time set out in Regulation 10, unless it's been extended under Regulation 65. Regulation 10 says that it must be made in writing in accordance with these regulations and be received by the tribunal no later than the first working day after the expiry of 8 weeks, beginning with the date that the notice of the decision came out, or the right to appeal under Part 2 was given. So there's an 8-week period for an appellant to bring the papers before the tribunal. And that, in fact, is the same in a claim. It's a different regulation, but it's the same period of 8 weeks. What happens in terms of responding to that on the part of the local authority or representative body, a responsible body? There is only 4 weeks. The case statement period for local authority or FEI governing body to an appeal is 4 weeks, beginning with the date on which notice accompanying the appellant's case statement is taken to have been received. And again, there's a possibility of extension under Regulation 65. Same for claims in another subparagraph. 2 comments about that. Firstly, if you think that you're going to need to extend that period, get in early, say why, give a realistic extension date to which you can work. There's no point in keep coming back attempting to get extensions. The second point, I think, is this, that I think local authorities and governing bodies of colleges are going to be need to be very aware that something is brewing and what the issues are likely to be. Because if they are quick and go get themselves going to make applications for, in particular, expert evidence, they've got 12 weeks effectively. As soon as they know, they should be getting on with this because they know there are these issues. If they don't, they're going to leave themselves short of time and clearly in some difficulties. But I'm afraid the argument, well, we didn't know that the other side was going to produce an occupational therapist's experts report. We've only got 4 weeks to do it in now because we've only just seen it in the case statement, will not wash. I go back, however, to the need to cooperate because such reports should be shared once they're received, not just at the end of the period. Excuse me. There's been some mention about NHS bodies. Can I just mention that there is a power for recommendations to be made by the Education Tribunal, and that means it can require an NHS body to give evidence about the exercise of the body's functions and make recommendations about the exercise of the body's functions. If it does so, there must be a report from the NHS body, and it must say what it's going to do or proposes to do, or that it's not going to do it, and this is why. So it's some attempt, I think, to enable the tribunal to have some power in relation to NHS bodies, but as you can see, it is fairly limited. And those reports have to come through within 6 weeks is the timescale. There is a new compliance power within the regulations. If an order is made at the end of the appeal process, the governing body or local authority must comply with the order. To be fair, of course, they nearly always have done in the past. But they now must comply with the order within the prescribed period, and the governing body or local authority must make a report to the tribunal stating whether and how it's complied with the order within a further 14 days. So there's just a requirement added in there to actually report back as to what has happened. What happens if that doesn't happen? well, there's a power to share documents and other information with the Welsh Minister. And that specifically includes the Education Tribunal. And so basically we go and tell the Welsh Minister if there has been a significant problem. I'm sure it will never arise. If it does, no doubt the Welsh Minister will look a bit like this, because he will be truly astounded that matters have got to that position, and will be giving everyone a rather quizzical look, in particular whoever is offended by not doing what they were supposed to. There is also some details about offences. It is an offence if, without a reasonable excuse, someone fails to comply with any requirement about disclosure or inspection of documents, or if they don't attend to give evidence and produce documents, and that can result in a fine on level through to, I think, is up to £1,000. Sorry, I've just jumped ahead. No, let's go on. Another quick word about capacity. The code of practice deals with this separately depending upon whether it's a young person or parent or a child. If it's a young person or parent who lacks capacity, the theory is that's going to have been identified by educational professionals, and of course one would hope it would be. If not, or in addition, there's specific reference to the Mental Capacity Act 2005. That has a code of practice and guidance all of its own, and in particular assists with who has to be asked about the issue of capacity in terms of professionals. And there are the 5 principles. I'm not going to run through them because they're probably familiar to most people anyway these days, but those are the principles under the Act which one has to bear in mind. So far as children is concerned, it's thought that teachers will know to a large degree whether a child lacks capacity, but NHS bodies and local authorities can also make an assessment. What are they assessing capacity in respect of? Well, it's quite specific, in fact, within the Act. It's capacity to understand the subject matter, and that means information or documents that must be given to a child, or what it means to exercise the rights conferred on a child by this part of the Act, so the appeal rights. Section 84 refers to various duties which are affected by that consideration. I won't go through them all for obvious reasons of time. Those duties to give information and do various things with a child or young person don't apply if the governing body, local authority or NHS body considers the child does not have the capacity. And of course, then we move to others who would have to be advised, parents, case friends, or other formal capacity representatives. What can the parents do if there's an issue about capacity? Well, first of all, the child, in fact, or the child's parents can request the local authority responsible to reconsider. So that's the first, as it were, almost right of appeal, but certainly to reconsider. If not, and then the local authority must make a decision, and it's a must once they're asked to look at it. Failing that, of course, there is the appeal route to the tribunal. I'll come to that. So far as participation of a child or a young person or a parent or a child is concerned, of course, the fact that a particular child does not have capacity does not mean that they are not to be engaged in the process. And specifically, 31.3 of the code sets out what must happen, even as it were, if you have an individual who doesn't have capacity. And then I just mentioned the capacity role of the tribunal. Within section 70, the appeal rights, a child or a child's parents could apply. For a declaration, the child does or does not have the capacity to do those 2 specific things, to understand the documents and the information, or what it means to exercise the rights of appeal. So it's quite limited capacity issues. because of course capacity is issue specific, as I'm sure everyone is aware. And then the tribunal may declare the child either does or does not have that capacity. Interesting point, I know we've discussed previously about that. Why is it restricted to the child or his parents? Does it mean that the local authority couldn't in any circumstances appeal to the tribunal? Well, it may be the way around that is to seek directions on an ongoing appeal to see whether some other evidence can be garnered in relation to this issue, because surely evidence is going to be required if there is a major dispute about capacity. Normally we'd have specific evidence from the experts that you see listed. Issue as to, of course, who's going to fund all that. If it's a child who lacks capacity, there's the case friend. I know we've had a question about that. It often is a parent or friend, so long as they've signed the relevant declaration. If it's a young person or it's the parents or parents themselves, it's as per the Capacity Act, which means a deputy appointed by the court, lasting on during a power of attorney holder, or possibly a parent. And I've set out the references to the code. Quick word about evidence and submissions. Just this, that the President or the Tribunal can give directions about what evidence or submissions they want, or what they want it to be about. So it is, the Tribunal does have specific powers to guide all this, as I'm sure those who've appeared before the Tribunal will know, but this actually makes it clear. That includes, and this is obviously a push in a slightly different direction, appointing a joint expert as a single expert in a case, a practice which has become commonplace in other jurisdictions, but not yet in the Tribunal. I hope it will become more common as time goes on. There's some regulations now about witness statements. I think that is to encourage more written witness statements. I don't understand at the moment why we don't get more written statements of what is the evidence of in chief of, in particular, educational professionals, if they haven't given a report. So expert teachers, learning support assistants, etc., they could all give their evidence by a statement. And this may also help to improve the blurring between representation and a representative giving evidence, which is not a big issue for the Welsh Tribunal historically, but it is noticeable if someone who's used to appearing before the English Tribunal turns up as a representative. Sometimes they are a little concerned about representatives seeming to give a lot of expert evidence or a lot of evidence at the Tribunal hearing. And there really ought to be that demarcation. You're either a representative or you're a witness. I'm not going to go through that. It just is to do with directions. One thing that is important relates to the assessment of children. This has been an issue in the past in two ways. And there is a new regulation which is designed to stop that. A direction can be given that the parent of a child makes the child available for examination or assessment, provided it's by a proper professional, of course. And the other side of this is if a school or educational setting is being difficult about such a professional coming in and seeing the child at school, or indeed seeing the child in a classroom environment, which is quite often important, again, there can be a direction, and that's to try and make sure that those practices do not continue of being difficult about those matters. If there's a failure to comply, then that will be a breach of directions. And I should say that there are lots of case management and directions powers now. And the reason that those are important is if there's a failure to comply, parties can have their claims thrown out or heard without them being present or providing any evidence. There's a discretion which I think is recognised as being new to go outside case statements on either side. And again, that's just about evidence at the hearing. Don't forget you can have a witness summons if you ask the tribunal for one. You must comply with tribunal orders. There's usually a period during which you must do that, and also it is quite important that there may be some battleground about who can or about who should be responsible for an IDP between local authorities and other bodies like schools and FEIs. A reminder that cost orders can be made. They are not normally made, but there are circumstances which they can be. They can be made against a party or indeed against a representative. Last word on time, ironically, given that we don't seem to have any now. Christmas holidays, summer holidays not included in time generally, doesn't apply to other holidays, and it doesn't apply where the tribunal has given a specific direction by a specified date. So beware of that if there are holiday periods which overlap with the time you've got to do something one way or the other. And that is the end of my presentation. So good luck, everyone. I'll just stop sharing now and come back to the main screen. Can I just close off by thanking everyone that's contributed so fully by giving their talks, to Emma, of course, for organising us all, and to everyone for attending. And unless there's anything else, I'm going to bring this webinar to a conclusion. Thank you, everyone. Bye-bye now.